Information governance kind of started in the intersection between technology and information management. It was a huge leap forward when Deborah Logan, then of Gartner, put out a blog post and new definition for information governance. Since then, IG has been spilling over the traditional delineations between information-related disciplines. Like the pervasiveness of information governance, too, has to go where the information goes. We've seen IG embraced by new communities, both disciplinary and industry verticals, healthcare, financial, legal, records management, privacy, eDiscovery. It's impossible to walk into these areas today and not find information governance. Next, we're continuing with our series of hallway conversations for InfoGov Day 2022. Sometimes in the hallways, friends gather. Other times, you meet new people. This hallway conversation is about the impact of information governance in the world of legal and eDiscovery, with 3 top experts in the legal and eDiscovery space, each coming from different perspectives. And while these folks know of each other, none of them have worked closely together before today's conversation. I'm glad to welcome a hallway conversation featuring the great legal and eDiscovery minds of Frederic Bourget, Leigh Isaacs, and Mike Quartararo.
Of information governance at DLA Piper. I've been here for almost a year.
Awesome. And I'm Mike Quartararo. I'm the president of the Association of Certified eDiscovery Specialists. My career is really eDiscovery focused, so not IG particularly, but anybody who knows anything about eDiscovery knows that eDiscovery, that IG is the foundation of everything that happens in eDiscovery. I say that all the time, and I feel like a broken record when I say it, but I think it's so appropriate. All right. Cool.
Yeah, I do too. In early conversations and early presentations I would do, years and years ago, this is before, the privacy and security and all of that became to the forefront. But, I was always touting the horn that I think that eDiscovery was one of the best things that ever happened to information governance because, it really kind of threw things into the forefront. And, anytime you're looking at making a business case for something, at the time, at least early on, there was a lot of value in that.
Yeah, no, for sure. And I came up through the law firm world too, so I understand and completely appreciate that world. I spent some time consulting, so I understand the corporate side of things. And of course, now I'm sort of in the middle of everything, so I get a little bit of everything. It's been a fascinating journey. What are we going to talk about today, guys?
Good question. Nick just sent a message on the chat saying that Leigh, you may have to exit and return sadly. Sorry about that. I think he's seeing the same thing I am seeing.
It could be. It looks fine from my end, but maybe it's just me.
All right. Well, I am going to scoot then, and I will be back. You guys continue on, and I will pick up when I get back.
Okay, great. Frederic, your thoughts on InfoGov as the foundation of eDiscovery. What are your...
Yeah, it's a kind of a broad topic, right? We've always known clean data kind of leads to easy discovery, easy eDiscovery, right? If I know where my data is, what it is, who owns it, all those kind of things, if you've answered the basic questions, it's easy to go and do your discovery and pull the right data in. So from that standpoint, it kind of ties together by default. And I think that's always been the base message. But I think there's certain things that are happening now from a technology standpoint, from an overall market standpoint that are somewhat, you're back, Leigh, and I can see you properly now.
Good. That's good news.
That are making things a bit more exciting from that standpoint, right? The whole idea of eDiscovery moving left. Right. And really connecting what is happening in the business with the eDiscovery process, having the ability to go do things like search in place. If you're going to index the data and have the ability to search in place and sift through your data where it is, Well, there's a whole bunch of things that are going to come up that are going to be relevant for IG and vice versa, right? If I do proper IG and I have proper control on my information, there are things that are going to come up that are going to be useful. I mean, the legal department, where organizations are asking them to actually reduce risk for the organization or manage risk for the organization, right? So when you look at it, everything that we do within IG is also about, right, privacy, holds, retention. It's about managing risk. So those, they tie into each other, at least at first thoughts, right?
Sure. So Leigh, while you stepped away, I just asked Fred, what's your take on IG as the foundation of eDiscovery? But do you want to weigh in?
Yeah, I mean, I guess to elaborate on what I was saying earlier, I mean, I think that years ago, eDiscovery kind of pushed the value and importance of information governance to the forefront, right? I mean, as far as the benefits of having your house in order, knowing where your data is, how you get to it, the value of it, the benefits of minimizing what you have, because the over retention of unnecessary information and the downstream implications on the eDiscovery process, all of those things that were pain points both from a risk perspective and from a cost perspective. I think eDiscovery kind of helped push information governance initiatives forward. But I think, Frederic, in catching the tail end of what you were saying, I agree 100%. I think that, to the extent that, on the far left side of the model, the better you're able to have your house in order and be proactive about things. And I think that's one of the challenges in IG is being able to stay proactive with as rapidly as the world is changing, whether it's from the rules and regulations to new technologies, things of that nature, to be able to kind of have that foundation in place, keep things current. I definitely think that to the extent that we're able to do that, it has those downstream positive implications on the eDiscovery side.
There's a great comment in the chat, and before we get to that, I just want to add from a pure eDiscovery perspective, like how do you identify, how do you preserve, how do you collect if your data is not in order? That's really, when I say foundation, that's what I'm talking about. Like I just can't do the eDiscovery piece without solid information governance practices. But a great question in the chat. The author would like to hear about how you get back to governing the data once litigation is over. A fascinating conversation you had there. Frankly, because it's so troublesome. Like when you put a hold in place, and what if you don't let it? What if you don't release the hold? What happens? Do you wind up retaining data that you shouldn't have? Do you then have to produce that later in some other matter? So let's dig in there a little bit. What do you think, Leigh?
That is a really good question, and that's one that, at every firm that I've been, there's been, I think a lot of discussion around. And I don't know that there's necessarily a one size fits all per se. I think, Mike, to your point about, implementing the litigation holds, and then if there's no process to come back and lift them, then you're over retaining things. And maybe veering off a little bit in a different direction, but still a consideration is more and more we're having to make sure we're compliant with outside counsel guidelines, right? What are our clients asking us to do? And are we over retaining things that they don't want us to have? I'm sorry, my cat has now decided he wants to contribute to the conversation.
Sure.
So I hear a little bit of background. But yeah, I mean, really kind of taking a look at what is the data that you need to keep. Do you need to keep the source data that comes in? Personally, to the extent that you're able to kind of get that, loaded into the firm systems and QC'd, would prefer not to hang on to that and to minimize the amount of information that you have, determine kind of what does then constitute, the record copy. And then make some of those decisions from a record standpoint as far as what you retain. Again, there's a perfect world that I like to live in, and I know that's not always reasonable, but when it comes to, from the law firm side and the client data that's coming in, I prefer to minimize the risk and the cost by not holding on to that any longer than we need to. I think that there's the work product that we keep, but then, at the end of the matter, what is that information that the client has given us? And, can we give it back? Or if they did provide us with copies, can we destroy it in a more timely fashion as opposed to continuing to hang on to it for, the 10 years that we may, have as our retention policy for our work product?
Fred, you are part of an organization, a software company, where I'm absolutely certain clients are retaining data beyond that which they need to. What's your response to this? What are iPro's clients doing in this space?
I think we see everything, right? So we see, just in terms of general policies, even we see everything from retention forever for everything, which is scary in terms of the amounts of data and the cost of that. But also the big question, and I think you brought it up nicely, Leigh, is with that data that you're retaining for eDiscovery purposes, for legal purposes, you still need to apply a whole bunch of things in terms of information governance to that information. And those are kind of outside your standard policy from a retention standpoint. But then what happens with privacy with that data, right? What happens with security with that data? What happens with sensitive information from a corporate perspective, right? So all of that you still need to apply. So I understand why from a legal firm perspective, you'd want to minimize how much you retain and how long you retain it as much as possible. But it kind of comes down to the same thing from a corporate standpoint as well. When you're looking at keeping data on hold, how long do you keep that data on hold? Well, as little as possible, I think is the right thing, because then you have the ability to kind of reduce that risk that comes along with all the other factors that are involved in keeping data, right? So that's, generally the challenge. And we tend to forget that when we keep data for 10, 15, 20 years, regulations and business practices and the right things to do have changed over that time. And what was appropriate to do, or, borderline appropriate to do potentially 20 years ago, is absolutely frowned upon today. So there's big risk to just, keeping data because, hey, we feel safer because it's right here. Well, maybe it's not the case, especially with breaches and security attacks that we have nowadays. It's like all over the place, right?
I was just going to touch on that, Frederic. I mean, the old, if you don't have it, you don't need to secure it. And, one of the things that, I have found is, we've got, the PII, PHI, all that sensitive stuff throughout the organization. A majority of that resides in the data that comes in from our clients. So, you want to keep all of that data secure regardless, but then you've got those, extra levels, I think, of due diligence and potential risk of those sorts of data types that are then out there in your environment that you have to be accountable for and make sure that things are secured properly.
There are two words that I like to use often, and they are defensible deletion, right? It's, if you don't need to keep it, as to your point, Leigh, get rid of it. If there's no legal reason, if there's no legal hold, if there is no absolute business need for a record, wherever it is, whether it's post eDiscovery or in the earlier stages back to the left side, why are you holding on to it? I mean, that's a question. I ask it rhetorically, but it's a fair question in our space. Like, look at the amounts of data that every organization retains these days. Why? What for? What is, if it doesn't have a purpose and there's no legal reason, what are you holding on to it for?
Yeah.
Well, and I think law firms too are, I think we're getting better, but have been notorious for wanting to keep it just in case.
Law firms are the worst.
Yeah. Well, one of the things that we come up against, and I certainly understand kind of the business need or the perception of value here, but for a lot of the client work, when there's repeat work that's done, there's that reluctance. Well, I don't want to have to go back to the client and ask them to keep sending us the same data sets over and over again. It almost becomes kind of a I don't want to say competitive edge, but to be able to say, yep, we've already got, your data. So, yep, you've got a new matter. We can, we don't have to start from scratch. We can just kind of keep going. And so those are, that's a common tension that I've come across when having some of those discussions internally about, can we just get rid of it as soon as we don't need it?
Yeah, no, it makes sense. It could be a competitive advantage to have a customer's data ahead of time, right? Especially if it's whatever repeat repeat events on the same type of data or the same area of data when you're talking about class action lawsuits and those kind of things that keep coming around with the same topics, right? And then it makes sense to say, hey, I can keep this data because when they come back, they will come back to me because I've already done the work and I already have the data. So it just makes sense. I think there's a new technology solution to that without tooting our horn too much, but having the ability to go, with permission of the customer in the right security framework, having the permission to go and search data in place and having those connectivity between the law firm and the customers can allow you to actually build that tie-in with the customer and that strength of interaction with the customer without having to keep data, right? Their policies, data is in place, it's in their environment, appropriately handled by them, but you still have that advantage of saying, hey, we have that connectivity to your data, let's go work together.
Yeah, but there's another side too, and that is, I'll just share an anecdote from a case, when I was back in my law firm days, and that is, we had data, and you're right, Frederic. When you have a client who has sort of serial litigation, maybe you can reuse the data. That's very effective and efficient. But there are instances where you say you're holding on to data from an earlier matter, and later on, perhaps years later, a new matter arises. Do you get yourself into trouble if there's something that in the new matter would be out of scope, but you still have it? So it creates a dilemma for lawyers, and I think professionals who work in our space, to assess whether I need to continue to retain that. Do I need to produce it? Do I have to look at it all over again? So it creates an inefficiency. That's why I say it's really...
Is that discoverable is what you're asking?
Right.
Yeah.
Exactly. So it creates an inefficiency, whereas, the goal should be efficiency. So...
Yeah, and there was just a comment in the chat. I wonder if the hourly billing approach, still in use by many law firms, acts as a disincentive to be more efficient in handling information.
Don't get me started. I mean, it's their model, right? That's what they've always done. I don't see it changing anytime soon. We all thought, I think years ago, alternative fee arrangements and fixed fee things would take hold, but I think they're still in the minority, very much so.
Yeah, I mean, we're certainly seeing, I think, a lot more, I guess, pushback from clients in the form of the outside counsel guidelines. If this is what we will pay for, this is what we won't pay for. But I still don't see this dynamic necessarily changing anytime soon either.
Yeah.
I want to bring up an interesting example that we've had lately, just because we've talked about security and security of data and all this stuff, and there are breaches, and the process to go through figuring out what has been breached, right? What is the data that we've lost, or where there is any personal information? Do we need to do notifications of those people, et cetera, is similar to eDiscovery, right? So that I'll go through my data and then that's been breached, and I'll try to figure out what's in there and tag specific information that would be problematic. And what I thought was interesting there is kind of the loop back into, well, if I find sensitive information in certain areas, and that probably is true in the term and for cases in regular discovery, if I find sensitive information that is in somebody's mailbox or somewhere else where it shouldn't be, there's a good opportunity there to have the feedback loop, right? And going back to the IG team and saying, hey, all of this information was in the wrong place. What policies, what controls do we need to put in place to avoid this from happening again and securing that information properly? I don't know if you've seen that kind of feedback both ways. Ideally it would be all classified up front. And then when you pass data to discovery, it would be, well, we know this part is sensitive and we're going to treat it properly from a security standpoint, from an eyes standpoint, right? Making sure the right people and only the right people have access and view that data. But in most cases it isn't, right? So do you see that feedback happening from the after the fact to back to IG?
Dive in, Leigh. You're actively working at a law firm. There's actually an interesting comment in the chat. Oh, I lost it now. Well, go ahead. I'll find it.
No, I mean, as far as kind of having that feedback loop back into IG, I guess the classic, I guess the records answer is it depends. There's some instances where I think that's happening with more frequency. I think a lot of it, depends on the firm, the culture of the firm. I mean, having worked at different firms myself, same title, different firms. There have been some that kind of see the value of having that, the IG loop and continuing to kind of close the gap on things. And then there's others that don't, and for whatever reason don't want to get behind it. So I do think though that it is a trend that is changing. I just think right now there's not a whole lot of consistency with that across various firms. My personal experience.
Yeah, and I agree. And to the comment in the chat, it would be interesting to know if firms that do take advantage of alternative billing arrangements are doing a bit. I think the answer is no. Would you agree? I don't know that they're taking. I don't know that they're doing a better job either way.
No, I don't think so. I don't think so. Yeah, and I know Jim just elaborated on my "it depends" comment, and even across various practice groups within the firm, that could vary as well. So it's not just necessarily at the firm level; it can get as granular with things being different within various groups within the firm.
Yeah, no, for sure. All right, what else? What else have we got on our agenda here? Other risks, challenges, and opportunities in the last 2-3 years. I don't know. I guess I'll say, what has COVID done to IG? Everybody moved to the cloud?
Well, I think it did that. There was a mad rush. I think a lot of what I'm seeing is kind of the boom of the use of collaboration technologies.
Yep.
Which, from the governance standpoint, has its considerations. So, it's one thing to just install it, flip the switch, and tell people to have fun, and then you end up, with nightmares like, unstructured shared drives and things that, we're still dealing with. So making sure that you've got the governance around that. I'm fortunate to work at a firm where we're having those proactive discussions and, to try to prevent creating some of those digital landfills. But I think that
Landfills or landmines?
Both. I would say both. That's a good question, but I would say both. And so I think seeing that shift, one of the other interesting things that I have seen is, while people are still using their paper, that was a big thing on the IG, the records and IG front, was trying to get the business case to stop people relying on paper as often. I mean, people were still printing paper, just for convenience purposes, but as far as, official file, really seeing more of a reliance on electronic. I was at my prior firm, and when things kind of were shut down, I was expecting a huge nightmare of file requests and just, having, how are we going to support getting these things to people that are working from their homes? And interestingly enough, the requests were very, very low, which told me that whether or not the electronic files were in the right place or not, they were somewhere and people were working with them. So it's been interesting to kind of glean those sorts of insights and then be able to build upon them. The business cases that we've been trying to make for a really long time about electronic file management, I think have kind of played out before our eyes because we've had to. So I think in some respects, not that I think we'll ever go back to the way that things were, we'll be defining what this looks like operationally going forward and making sure that we continue to go forward and not start to creep backwards as people start making their presence back in the office.
Yeah, I'm wondering, Leigh, if people have started, because I know, especially in law firms and the good old habits die hard. Are people printing this stuff at home and doing piles of paper? And maybe that's another risk to consider from kind of going back to an old risk of, hey, I've got paper in the wrong places, right, where I don't want them and not secured and not anyways, just a thought that crossed my mind. I think from a general COVID perspective and the move to work online, we haven't understood the impact yet. We haven't, great if you guys are talking about it and really structuring all of the policies properly around that. I think it's going to be a surprise in a lot of cases, right? A lot of the conversation we were having verbally, we're doing this because we don't have verbal conversation anymore, but a lot of the conversation we're having verbally are now electronic, which means they're discoverable. So all those hallway conversations, all those things that you said to someone that, I don't know if I should have said that. And it was just a thought passing by. Well, now it's written and it's a record. Right. And that becomes challenging. I think that could become really challenging. And the amount of data as well, right? Managing, 100,000 email in somebody's mailbox is very different than managing 10 million messages in their chat lists, right? It's from a data perspective, it's a completely different scale. So all of that, I think, is we're in for somewhat of a surprise 1 or 2 or 3 years out when litigation for this period start really coming in where we have to dig into that data. And a lot of organizations didn't have time to put the right policies in place, didn't have time to put the right, I think most organizations at least tried to do the basics from a security standpoint. But for the rest, from a privacy, what are the rules? Am I allowed to chat about an employee in chat? With regards to their benefits or things like that or not? How is that done? Normally, I'd walk up to HR, sit down in their office or have a call. Like, what happens with all of that discoverable data and how sensitive it is and what do I need to do? I think those are questions that I think the answers are not hard to find, but organizations haven't put these policies in place, haven't trained their people around that, and we're still up in the air, right?
And think about
and we all had to respond very quickly, so there wasn't necessarily the luxury of time to be as methodical as perhaps we otherwise might have liked to. I think one of the other interesting things that I have seen come up, and I expect that it's going to continue to grow, which makes interesting challenges from the law firm client file governance perspective is, I think, not just law firms are kind of jumping on the collaboration technology platform, but our clients are as well. And so we're getting some requests from clients to say, okay, this is how we're going to work. We want you to meet us in our environment, which means all of the documents live in their team site, all of the chats and the discussions live in their team site. And then the question becomes for firms, how do we then best capture the client file that we need to keep and we're entitled to keep, and what does that look like? So, and I don't know that there's, it's been coming up, but I don't know that there's any kind of magical solution to that just yet. And I expect that that's going to continue.
I think chat is one thing, but what about video, right?
Mm-hmm.
Video, in case anybody hadn't noticed, takes up a lot of space. And so what does that mean for storage? And then I'll go one step further. What about those instances where people don't even know where the file is stored? Like if you're not set up in your environment in a certain way, some people don't even know that like chats are recorded in some obscure location. And how do you get that? How do you retrieve that? Is it stored locally? Is it on a server somewhere? Is it an enterprise edition, or is someone, rogue on a Slack platform and there's data that the organization can't get to that's highly relevant? It creates such a nightmare.
Yeah, and even the file sharing, right? We have exploded file sharing nowadays. It's no longer like, hey, here's the drive, let's put that data there. Although I suspect law firms are a bit more structured. Corporations are just, hey, it's in my OneDrive, I'm going to share it to these 5 people. And then somebody else at the other end of the organization just goes, okay, I'm going to share it with these other 5 people with, by the way, 3 people are actually external to the company. And now that person who's sharing the document doesn't even own that document. It's somewhere else on somebody else's OneDrive, right? How do you kind of tie all that together is really difficult.
There was actually a court decision on this, I want to say mid to late last year, about links in an email, and the links are to an internal source, and anyone outside the organization can't get to the source. So producing the email with the link only and not having access to the document that was effectively attached as a link, right? It created a discovery nightmare for a party in a litigation here. I think it was here in New York in the Southern District.
What was the outcome of the decision there?
It was actually, my recollection is that it was a poor decision because the judge, I believe, decided, I have to pull it up and look, but I believe decided that it was okay in some instances, and because the party who had produced the email with the link had gone back and done a follow-up and said, oh, here's that document, although the receiving party, I think, had to then go put the two documents back together. Which was problematic in and of itself. But I think on the limited facts in that circumstance, it was deemed acceptable. And it created a little bit of an uproar in the eDiscovery space because they're like, no, that's not a document. That's a link. Give us the document and attach it to the email so we know the person who sent that email also intended for the recipient to have that document. It creates a little bit of a problem.
I mean, that's the case with chats and Teams and Slack and all this, right? The documents are not there. It's most of the time it's links. Even Exchange now has these smart attachment things that the attachments is never in the email. So yeah, it's absolutely an issue for sure.
Which is interesting because, from the IG standpoint, that's often what will be promoted as best practice, right? Internally, let's reduce the bloat on email and everything else by avoiding throwing those attachments in there, and let's use the links instead.
Yeah. Interesting, yeah, because it brings down your redundant data for sure, because you're not copying over in the emails over and over again. It's that one file, and everybody edits the one file, and we all hope we know where it is and it's properly stored and properly secured. But that's the challenge with distributed sharing the way it is today, is you're giving that security out to the users, right? Every user gets to decide what they want to do with those documents. I guess maybe it was a bit the case in the past, but if you were going to pull a document from a document management system and share it over email, you'd have second thoughts maybe, compared to just, hey, let me forward this link on from the top of the document in the corner of the window. A lot more effective, but maybe a bit less secure. Yeah.
I'm putting in the chat the name of the case. I found it.
Oh, interesting.
Yeah, I had heard about that one too, but I had actually forgotten about it, so I'm glad you brought that up.
You brought up, Michael, earlier video. I think it goes further than just how big the videos are. It's also about, hey, if I need to discover video and conversations in video because they're records, how do I do that, right? Do I need to pull in, complicated tools to be able to analyze and do speech to text and all the rest that comes along to be able to say, hey, this was or wasn't relevant? It's a step up from just being able to search emails and documents for sure. So, keeping those videos is a big question, right? And what is the retention policy of the organization? And are those formal records or are they not? And if you recorded them, there must have been a good reason for it, and potentially a business reason, but maybe it was a records retention reason as well. So I don't know how you solve those problems easily. Not that the technology doesn't exist. It's just it's costly.
Yeah, absolutely.
Yeah.
Let me see what else have we got on our agenda here. Feel free to dive in, guys. Anybody in the audience, if you have a question, throw it in the chat.
Yeah, I was just going to say anything the audience wants to talk about. I know for IG, although this has been kind of an age-old dilemma, I think, for me, it continues to be a balancing act of continuing to deal with a lot of the legacy stuff. So there's always those things that have accumulated over the years, the stuff that needs to be cleaned up, anytime you turn over a rock, a whole bunch of things kind of crawl out and you're like, oof. The legacy unidentifiable data, especially, if you're in an organization that's gone through, growth through mergers and things like that, there's just all sorts of surprises out there. And then kind of keeping the day-to-day going, and then, trying to be proactive and anticipating kind of what's coming ahead. And I think that, just with the changes in technology and the landscape and privacy regulatory issues, all of those things become even more and more challenging. So for me too. One of the important things, and I think a value that IG can bring to the organization is kind of being that connector between all of the various disciplines within the organization, whether it's privacy, security, IT, general counsel, to be able to kind of connect the dots on a lot of that stuff. I'm seeing, and it's been very interesting, not just in law firms, but across various industries. Doing a scroll through LinkedIn, there seem to be a whole lot more information governance kind of senior roles that are emerging within organizations. Companies that never had them before, law firms that never had them before. So it almost feels to me like we're getting to a point where, whether it's a tipping point or not, I don't know, but organizations are recognizing that there is some importance here, and there needs to be senior level ownership to be able to kind of own and guide it within organizations. I don't know what have your guys' perceptions been?
Yeah, I definitely see a rise in the CGOs and the CISOs, right? They're starting to think more strategically about it across the industry, not just at law firms, not just corporate. Government is thinking about these things, and it's really, in my view, it's coming about as a result of information security, cybersecurity. It's because we're starting to see much more regulation in privacy, and there's much more concern around how we're protecting information, generally speaking. We work in an industry where if you don't know, you have somewhat of an ethical obligation to go find someone who does. So I think that's what we're seeing as a result. We're seeing the influx of the IG professionals that are needed to help protect the information, to secure it, and to manage it, frankly.
Yeah, I think you're right, Michael. It really comes from security standpoint, the scare of so many organizations are getting breaches or getting accounts hacked or getting this and that. For most organizations nowadays, their information is their key asset, right? It's their value. It's what the organization stands on. So when that gets dilapidated or sent on the internet, then your value diminishes. So
Yep.
I think it's a key item in terms of driving IG. And I think legal team we were talking about earlier is how legal is there to help reduce risk. I think legal teams are seeing that as well. So we're seeing IG professionals within the legal teams, as being a senior person that has to help with policies and organization. Although we're seeing it everywhere in security and IT, but it's just interesting to see them in that role as well, or in that organization, that part of the organization.
Angela, there's a couple interesting questions in chat. I'm sorry, Frederic. But Sandy asked a really good one, I think. So, question for the panel: are law firms required to maintain content records in accordance with their clients' policies, and what does that mean for the client data that you hold? I think that's a really good question. And it's a tension that we feel in law firms, right? Because I don't think operationally we can necessarily comply with every client's specific retention policies. So usually when those discussions come up, there tries to be a kind of a meeting in the middle of, okay, this is our retention policy. Better yet, when we're done with the matter, we'll send it back to you, or we will destroy it, fill in the blank. But to kind of get granular in that we will manage to your retention schedule for, all, however many record types that you've sent over to us, is not, I don't think, is a sustainable solution. So we usually try to work through to some sort of other mutual agreement for that. Because honestly, realistically, we could agree to it, but I don't know how you'd be able to comply. Especially when you're talking about, like a firm the size of mine, and how many clients are going to have those sorts of requests, and they all may be different.
I'll share a little anecdote in that regard from my time at the firm, and it really came about as a result of a partner with a series of clients leaving the firm, right? And when that happens and a partner is taking the client with them, it raises a question: who owns the data? It's the client who owns the data at the end of the day. And I think a lot of people, that's a nuance in the legal space that not everybody's aware of. So whether you're the law firm who has all the client's data or not. The client still owns that data. So my experience was we always deferred to whatever the client wanted. And usually the default for us was to try to return it to the client. Let it be their problem, right? The best way to get something done is to make it someone else's problem. I hate to say it like that, but that was an easy solution. So at the end of a matter, if we knew it wasn't going up on appeal or going to hang around for a while, we would ask the client, what do you want to do with this data? So it's a great question. It's a conversation that needs to be had, because if you think about it, what makes law firms vulnerable is that they have all this client data. All right, so get rid of it if you can. To the conversation earlier, if you don't have it, you don't have to hold it.
Yeah.
I like Angela's question. She's asking, 20 years from now, looking at all the legacy data and information, what do you think eDiscovery is going to be looking like?
Oh, I was hoping to avoid that question.
I'll try out.
Well, we IT folks are going to get it all cleaned up, so it'll just be nice, neat packages of data for you all.
No, the tools are growing too, right? The tools are really growing, and I think we'll be in place. We'll have the policies and the tools to be able to see what's in the data and be able to classify, organize it. The compute is growing to give us the possibility of doing that, right? So once you have that, you know where your data is, you know who has access to it, you know when it needs to be deleted. Then why would you even move the data? Just do the discovery in place, bring the people on the data. Yes, you can still build all the metadata and all the information that you need to be able to move your case forward, but just don't move it. Just like we're doing with file sharing today, just leave it there and keep doing what you have to do. And I think that's the 20 years out. That's the ultimate thing, right? Where you don't have to move data into law firms. Law firms come and do their work, and then they walk away and the work is done and they keep the work product. But we'll see if we get there. That's my dream, anyways.
I want to be a little bit more skeptical, and maybe I'm just a little more cynical about it. I don't know. I'm wondering about the disparity of all the different organizations, right, and all the different ways that people manage this process, and the different tools that are out there. Yes, the tools are becoming better. Of course, I hope technology evolves and there becomes some more standardized processes, but I feel like every organization has their own sort of way of doing things, their own culture, their own management, and it's hard to get everybody on the same page. I don't know. Maybe I'm not as optimistic as you, but I agree it needs to happen. I don't know. What are your thoughts?
20 years is a long time. That's why,
it's a long time. That's the entire generation.
Yeah, I think I fall somewhere in the middle of you guys. Yeah. I'm optimistic, but I also think that culture and other factors play such a role in
that's the part that scares me.
In where things go and how you get buy-in and support for certain things that, we could have the greatest technology tools there are, but if you can't work through some of those other dynamics and hurdles, it's still going to kind of prevent you from getting to that perfect world.
Yeah, potentially. And there's going to be new organizations or new cultures that grow up that don't have necessarily the right thought process. We've seen that over the last 15 years with a whole bunch of stories of improper data management.
Yeah, I know we're coming towards the end of our time, but I did appreciate one of the comments in here. We will totally have the tools perfectly smooth and easy just in time for retirement.
Yeah. Well, at least we'll have accomplished something.
Exactly.
That's right. Gen Z doesn't even know what a file share is. Anyway, all right. Well, this has been fascinating. I think it's a great conversation to have. Love to continue it, but we are running short of time. Anything else? Anything else we need to talk about? Any big news to share? Legal Week is coming up for anyone who's interested in that. Here on the East Coast. I don't know where everybody is today. I'm sure we've got an audience from all over the place.
I saw a few hellos from different areas, different places. Yeah.
All right. I think we'll wrap up. I don't know if Nick is coming back in or if we're just signing off. I guess we'll just conclude our conversation with 30 seconds ago. Closing thoughts, Fred?
Thank you to everybody. Well, just a big thank you for everybody participating in the conversation in the chat. That was great. Yeah. Absolutely.
Oh,
and really nice meeting you, Michael and Leigh. And hope we can continue this conversation under other other areas.
All right, cool. Leigh, any closing thoughts?
No, I just echo what Frederic said. I appreciate everybody's involvement. I thought we had a great discussion, lots of great info in the chat, and I hope we find a way to keep this conversation going too. Back to Nick's intro, we didn't do so bad for three of us who haven't spent a whole lot of time together. So
Yeah, no, I think this sort of impromptu, organic conversation is the kind of thing that needs to happen in the industry, because it really fosters some great conversation, and I thought it came out nicely in the chat. So thank you. Thanks everyone for joining us. Thank you, Nick and InfoGov.net for having us today.